This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are talking with Greg Lukianoff of FIRE about his impressive new book, Unlearning Liberty, Campus Censorship and the End of American Debate. Greg Lukianoff is an attorney and president of FIRE, which is the Foundation of Individual Rights and Education. In this capacity, he has litigated numerous cases defending the First Amendment rights of students on college campuses around the country. For this work, he has received numerous awards. He is also a regular columnist for the Huffington Post, and his pieces appear in the Washington Post, the Boston Globe, and the Los Angeles Times, among other publications. Greg, it's great to have you.
Thanks for having me.
So I just want to ask you a basic question here at the beginning about the title of your book, Unlearning Liberty. What do you mean, unlearning liberty? Do we not all desire freedom? And this was kind of the contention of George W. Bush. Every human heart desires to be free. Have you found this to be true on college campuses?
Well, unlearning liberty refers to something we see happen on a lot of campuses, where students start to really believe that free speech and basic rights are actually sort of the enemy of progress, as opposed to a necessary component of them. So when we see student governments, call for speech codes, or we see students running around campus destroying entire runs of student newspapers because they don't like an article that's printed in it, or when we see Harvard law students writing papers actually defending the existence of speech codes from a legal perspective, which is crazy given that there's no legal basis for that. That's unlearning liberty. That's what we're concerned about. That we have a generation that at its less at a deeply troubling level, they've gotten just too used to being hyper-regulated. They accept that they can be told to get to a speech zone that's, in the case of University of Cincinnati, 0.1% of the entire campus, and still have to apply 10 days in advance even to use that. And to me, that's very worrisome because, those aren't the habits of a free people. They shouldn't be looking to government. They shouldn't be looking to those in authority to tell them when, where, and what they can say. But on an even deeper, more worrisome level, it's when students actually start to conceive of the idea or of the romantic censor, that is essentially someone who is a censor, someone who burns student newspapers in some cases, someone who goes after speech that they dislike. Unfortunately, that's been able to, in some cases, take on an almost noble stature, a sort of ennobling kind of idea that actually the people who are going out and censoring in a quote-unquote enlightened way are actually, to some sense, romantic heroes, and that's the even more dangerous manifestation of unlearning liberty.
So you have essentially kind of mob rule being applauded or, at the very least ignored on college campuses. That certainly I've heard of that happening, particularly with regard to, say, conservative student newspapers their offices being invaded, and then actually their capital and their materials being burned or destroyed right in front of them. I've read of those cases. Let me ask you. You refer to a speech of the great jurist Learned Hand, where he said, "The spirit of liberty is uncertainty." I think that's almost an exact quote, which I thought that was important. And yet also, as I'm thinking about your book, liberty requires uncertainty. And yet I also wonder, are there not also things we have to be certain about? Is there something happening on college campuses by way of students actually don't believe in reason itself, that rational argument can actually get somewhere? And if rational argument can't get anywhere, why actually have it? Why have free speech? Why have freedom of association where people can congregate together and discuss with like-minded people before they then go out and then address their opponents? Because if that's true, then words would actually be projections of power, matters of group identity, matters of class, etc. And then the real task becomes to find the values in groups we want to project, we want to favor hierarchically, and we allow their words to matter. That seems to be at least one way to think about the college campus situation.
And what I talk about sort of the hero narrative, kind of related to my previous point on campuses, where there's sort of a carrot and a stick that universities create, and it's not just that universities are tolerating, mob rule and mob censorship. It's that they're teaching it, in my opinion, through speech codes and through their own actions. And actions speak louder than words. And in the book, I covered dozens and dozens of the thousands and thousands of cases that I've seen over the years, where university administrators have shown how not to live in a free society, how to embrace censorship, and how to try to wear that as something that's noble. And what ends up happening, but the carrot, the thing that sort of encourages students, is what I call the hero narrative. The idea that if you're committed enough to fight speech that you consider offensive or oppressive, that really what you're trying to do at that point is not rational. It's anti-rationalist, actually. And the word I use for that actually is romantic. And that it's the idea is that if you're really committed to the cause, then facts be damned, reason be damned. I'm standing up for what I believe in, and that means that basically by any means necessary is acceptable. And I think that this the worst kind of cultivation of this happens in university programs like the one I cover in the book at the University of Delaware, where it really was a complete invasion into the private consciences of every student at that college. Yet when I actually went to address the college about this, insanely unconstitutional program, the students really felt that since it was trying to sort of accomplish what they considered to be a positive good, in this case, rooting out racism and sexism, that it didn't matter if the techniques they used were, tyrannical.
What was that program specifically at Delaware?
It was a program that was literally referred to as a treatment by the administrators, which gives you an idea. All 7,000 students had to participate in mandatory floor and one-on-one events. The floor events included group events where you had to stand on one wall if you had one opinion on issues like welfare or affirmative action, and the other one if you had the right opinions about that. So you weren't allowed to. You were required to take a side. So, for example, they talked about eating disorders, and the question was whether it's socially constructed or if it's something that is more a personal idiosyncrasy. And there was a girl who was participating in this who asked to opt out because she had an eating disorder. She'd struggled with it, and she didn't actually know herself if it was just a cultural thing or just something unique to her. She was required to participate in it, and she was not allowed to stay in the middle. She actually had to choose a wall. And as best I can tell, the correct answer, as far as these administrators were concerned, was that it's just a product of culture. There was another part of that program where a student, again a female student, was handed, and like all the students on her floor, was handed a mandatory questionnaire about what races and sexes she would date. And when she was asked the question, when did you discover your sexual identity, her answer was, none of your damn business, which is very appropriate given this is a state employee asking someone about their sex lives. And she was actually the one who was written up. And this whole program was run by a residence life system that actually had a professor called Shakti Butler come to teach students about about racism. But her definition of racism was that every single white person is inherently racist. No non-white person cannot be racist. And it was it was residence life job to essentially cure students of their privilege and of their, of course, insidious racism.
I wanted to ask you. I mean, I guess the residential programs are troublesome. It seems to be where the rubber meets the road because you literally have the captive audience that you can force to do things. You hold something large over their head, which is, of course, the penalties, but yet the fact that you're living here and you're on campus. So you do have that problem, and the Delaware problem I remember reading about at length, and that was shocking. I want to ask you, you make this point in your book of kind of a basic contradiction, a generational contradiction, or not a generational contradiction, but one generation doing two things, two different things. One, protest in the 1960s on campuses, the refusal to be, in effect, told what to do, a very aggressive speaking out. And then this same generation, as they begin their march through the institutions, does not maintain those standards. It seems so. We have kind of two things going on. One is a rising generation, as we've kind of discussed, not really seeing the value in free speech, not seeing the value in controversy and difficult conversations being had, difficult debates being made. And yet also they're, so we say, campus masters and their own contradiction. And yet I'm wondering, wasn't that precisely their point, in the sense that universities no longer were the universities of the liberal ideal, but were agents of social change, or part of the social change process, I should say?
Yeah, that's something that Alan Charles Kors refers to as the great generational swindle. The generation that was very pro free speech and pro the free speech movement turned around when they got in charge and imposed speech codes and speech zones. But there was always even within that movement, though, there was always a tension. There was the 1975 Woodward Report, which was at Yale. C. Vann Woodward, famous historian, did a history of academic freedom in order to defend the university's strong commitment to freedom of speech. But and many people know about the Woodward Report, they don't often remember that it has a dissent in it. And the dissent is all about the sort of Marcusean, Herbert Marcuse idea of repressive tolerance, that essentially truth doesn't exist, we can't know it, we're all inherently biased, and so therefore we should actually advocate for things that go beyond merely tolerating free speech, and if we really care about a fair society, we should engage in enlightened censorship. Now, even in the Woodward Report, this argument is a very bad argument, because they seem to think that the founding fathers and the great thinkers throughout time, or thinkers today, hadn't actually accounted for the fact that people aren't good at knowing truth when they see it, and that people tend to be biased and tend to have confirmation biases, and tend to can be very self-deluding. But free speech is the great answer to that. That essentially, if this is the fundamental problem with society, if it's a fundamental problem with human nature, that's an argument for not putting anybody in charge of what people are allowed, what opinions people are allowed to have. Because the smaller number of people that you put in, you actually amplify that problem of bias. But they were actually using this argument, which in my opinion is a absolutely clear argument for freedom of speech, as an argument against freedom of speech.
I was going to ask you, in thinking, there's a lot of interesting parts of your book that I want to get into. One is, it seems my experience on college campus and my experience in law school is you have something which a lot of people have spoken about, but I think don't truly appreciate the magnitude of, and that is really the decline of the humanities and the idea of the liberal ideal, that you actually go to college to read books beyond your experience, important books in literature, philosophy, political economy. You do math and science, it's hard. And so you're constantly being stretched, and that's good. And the professors are there and aren't necessarily chauvinistic about it, but they're wiser than you and they want to give you something. Contrast that now with how a lot of professors see that role, how a lot of campus administrators see that role. They're there to push you in a direction that's very political, that's kind of hyper-egalitarian, et cetera. And then so you have that decline, but you also have the rise of the vocational model. I'm here to get essentially the degree, which is really just a signal to employers, doesn't actually mean that I know that much. And it almost seems like the multiculturalists or politically correct crowd, hyper-egalitarians, kind of win these debates by default. It seems in large measure, but it seems to me there's a basic problem on the campus with how we think of the university and what it's supposed to be about. In particular, you see this I thought I saw this in my law school a lot, that it was just, even in class, it wasn't important to even have the discussion, given the level of volume of the voices you had to encounter.
Absolutely. Yeah, and that's one of my points with the learned hand quote. The true spirit of liberty is that which is not that sure that it is right. And the certainty theme that's all throughout it. And I understand the argument for certainty, but that it has its value. But I do think that we don't live in a society that has too little self-doubt at the moment. We would not, where we have too little introspection. And universities, the worst of the professors have taken on this role that's not so much sort of a classical educator, the idea of bringing knowledge out of someone, actually, and showing some amount of, epistemological modesty, as David Brooks would call it, in front of the wide open and interesting, nature of reality. And what they don't seem to get in some of these cases, some of these professors, is how extraordinarily arrogant they're being to presume that they are actually the unique holders of absolute truth, and that it's simply their job to put it into students. Probably the scariest manifestation of this is Fire is very fair in our defense of all opinions and professors and students. So there's a chapter on our defense of professors, but there's also a chapter on abuses by professors. And I actually think the abuses by professors are probably scarier, because they involve professors, particularly in schools of education and schools of social work, who see no moral problem whatsoever with actually requiring, in order to graduate, students lobby the government for, in many cases, usually progressive causes they don't believe in, and that's terrifying.
You mean making that a part of your coursework?
Yeah, you literally have to go
wow.
lobby the Rhode Island state government or the Kansas state government, or in one case Washington state, to actually lobby them for a limited number of causes that are all that conservatives, and in the cases I talk about, a conservative student in Rhode Island, a conservative student in Washington, an evangelical in Missouri, an evangelical in Missouri, all being told to advocate for that they had to advocate for causes that went completely against their actual beliefs. And when universities have lost sight of the idea that yes, it's terrible to tell people what they can't say, and Fire utterly opposes that. It is much scarier, though, to believe that you have the power to tell people what they must say.
No, that is incredible. It seemed there was an interesting clue. I thought the University of Illinois, Urbana-Champaign. I think maybe it was 2 years ago. There was a professor teaching a moral philosophy class, and just the idea of I think it just kind of came up, sexual ethics. And he showed how different philosophical traditions would deal with these questions: utilitarianism, a natural rights perspective, a classical natural law perspective. And he just made the argument. And that enough was, and this is on the question of homosexuality, that enough was compelled his removal from the classroom, according to the University of Illinois. But it was interesting, he was reinstated after a while, but it was interesting the response of the College of Arts and Sciences provost at Illinois said, our job here is to make the students comfortable in their learning environment. And when I heard that, it seems to me this really does get to this question of, what do we think about reason? What do we think about rational argument? Versus compelling speech or compelling belief, or leaving things alone because we already know the truth. So there really is this closed society versus open society dynamic going on. I want to ask you, there's been a lot of talk, and you write about this in your book, of due process on college campus, in particular judiciary proceedings on college campuses, completely ignoring due process violations that we expect and demand in our courts, particularly with regard to criminal investigations or accusations. This is not the case, and this has been going on for a while. But then now the federal government has become involved, and the Department of Education, the Office of Civil Rights within the Department of Education, has actually demanded, as a condition of funding to state colleges, that they have to lower their standard of proof to preponderance of the evidence, which is, as you say, 50% plus a feather, and you're guilty. And so then this serious criminal allegations is a problem.
Well, the issue of due process gets its own chapter in the book, and it's a topic that I think particularly parents should be concerned about, because we have this, forgive the expression, but sort of double whammy problem of universities at one level writing codes that are so broad that all students are already guilty of them, particularly when it comes to things like sexual harassment. Some of these codes are, and I have a whole chart in the book talking about our speech codes of the month, And probably one of the more ridiculous codes, but it's actually kind of typical, was at Drexel University, where they defined sexual harassment as being inappropriately directed laughter. Something so vague, and also something that someone has arguably done at some point or another. And Chico State University had consistently using the masculine pronoun in order to mean a person. So basically standard journalistic practice at most places in the country would be technically harassment at Chico. So you first have this problem that some of these offenses are defined so broadly that everyone's guilty of them. And then the Office of Civil Rights, Department of Education comes in, and I think they may be the only institution in the country that thinks there's way too much due process on our college campuses. You look at the attitudes reflected in the Duke lacrosse case. You look at any other fire case that's happened. You hear horror stories about kangaroo courts on campuses. Not wow, students are just they enjoy way too many due process rights. But the Office of Civil Rights, in an effort to combat, the very real problem of sexual assault on campuses, since they didn't actually have direct power to police sexual assault, they decided that they would look at sexual harassment codes, and since assault is just one very extreme version of harassment, and that's sort of a morphing of the law over the years, that they would lower the bar for the definition, for the level of certainty you had to have to convict someone of harassment. So first of all, we have codes that are make everyone guilty. Then the next step is that the federal government now requires universities, when they adjudicate this, to use the preponderance of evidence level of evidence, which is the lowest the judiciary offers. Now, most of the best schools in the country had it clear and convincing, was the standard that they used, which is considered more like 75%. Meanwhile, preponderance of evidence is, to quote one administrator, 50% plus a feather. If you have the slightest inclination, 50.0001% more that maybe the accused is guilty, you're required to find them guilty. And it really creates a potential due process disaster for students. But all of this is almost certainly going on in secret. University tribunals have they hide behind a law called FERPA, which was originally intended to protect the academic information of students, and has increasingly become used by universities to just hide hearings and hide disciplinary hearings that now include things as serious as assault and rape. And I think that with these factors together, we're trusting. Not only we're trusting much too much in institutions that are not cut out to handle criminal cases, and then we're requiring them now to be less certain that people are guilty in the first place.
Who sits on the? I mean, is it students, faculty, administrators, a mix, or?
It's different depending on the school.
Okay.
Some of them have a combination of students and faculty. Some of them are just all students. Some of them are just administrators. Some different colleges have tried to set up specific tribunals set up just of administrators to adjudicate these sort of things, but with a given the makeup that Columbia, for example, was proposing, it was with a very strong bias towards finding students guilty.
I mean, I guess I'm listening to this, and maybe this is a dumb question. I mean, are these not just per se unconstitutional if they're challenged, or on state colleges, or is that? I mean, or is the standard of evidence for guilt something that they can maneuver with because there's not actually a actual criminal penalty? You would just be dismissed from school. I don't know. Yeah,
there hasn't been. The problem is for someone to challenge this, it would usually require an actual university willing to directly challenge this, and it would require a student that would be willing to challenge this. But they'd have to make the argument that the but-for cause of them getting preponderance of the evidence was the Department of Education, which is an argument they can make. But the problem is that since these are done in secret, since there's tremendous pressure to keep quiet, that a lot of students aren't coming forward to challenge them, even though we get complaints about this on a pretty regular basis, it's usually with the caveat, yeah, but I can't talk about this publicly, and I certainly can't sue.
Okay. So let me ask you, there was an important Supreme Court case in 2011, I think it was early 2011, Christian Legal Society versus Martinez at the Hastings College of Law. And the law school, and as you know, I wasn't aware of the factual record, noted that this was an all-comers policy. Any student association at the law school had to accept anyone regardless of belief, commitment, ideology, et cetera. And they applied this to an evangelical student group, and the evangelical student group was de-recognized because they refused to adjust their faith requirements and also their requirements on sexual morality for those to be members of it. And they were de-recognized. They sued. It went to the Supreme Court, and the Supreme Court, an opinion authored by Ruth Bader Ginsburg, affirmed the right of the university, of the law school, to de-recognize them because the policy was an all-comers policy. Although you note the factual record notes that the law school was playing fast and loose. It never was. And then it seems to be only applied to the religious groups. And then this holding was affirmed subsequently in a case involving San Diego State University, where it was made even worse, as you document, and that it was just applied to religious groups. So even the all-comers policy rationale, what's going on there? I mean, why? I mean, this almost seems absurd that, in effect, you could have the Jewish kid become president of the Baptist Student Union on college campuses.
Well, it's something that if you had told me before I worked at FIRE that I'd see systematic abuses of evangelical Christians or of Christian groups on campus, I would have probably said, oh, that just sounds like some kind of conservative propaganda. But I see it all the time. And it primarily comes down to universities. Well, one, they have a huge double standard. They disapprove of where Christian groups stand on particularly sexual morality and homosexuality and gay marriage and those kind of issues. But the double standard comes in from the fact that so do the Mormons, so do the Muslims, so do conservative Jewish groups, so do a lot of the older religions. But they they suddenly become aware of this in application to the evangelicals. And what's been going on a lot of campuses is that if a evangelical group has a statement of faith that it wants students to sign in order to join, the evangelicals are being told that they can't do that. And universities are good at coming up with any kind of excuse that they can muster against them. And the one that they've sort of settled on is that, and it's kind of amazing to say this, that's discriminatory against non-Christians. And we always have to explain this status versus belief distinction. Yes, if a university wants to say that a group can't discriminate on the basis of race, that makes it's perfectly fine. That's acceptable within the law because there's nothing about being of a certain color that means you can't have certain beliefs. But expressive association is all about, quote unquote, discriminating on the basis of belief. Christian groups should be allowed to be Christian. The college Democrats should be allowed to be Democrats. The college atheists should be allowed to be atheists. And the college environmentalists should be allowed to kick out people who don't believe in global warming. This is basics, pluralism 101. But universities, in their different attempts to try to figure out ways to kick out evangelicals, had settled upon this. And FIRE had actually been very successful in fighting these cases case by case basis over the years because it didn't stand up very well to public scrutiny at schools like University of North Carolina to tell an evangelical Christian group that they'd have to let atheists join. And this was actually happened to a group that was literally evangelical, as in like they would go door to door, and just the idea of having a group, how you could actually do that job and try to convert people over to their brand of Christianity. If you're saying, well, I don't actually believe this myself, you should. It's just ridiculous. And unfortunately, the Supreme Court, in a very muddled decision, including an almost incoherent opinion by Justice Kennedy, decided to say that this policy of having an all-comers policy, which means that any student group has to allow anyone who wants to join, no matter what, would only be acceptable if it was enforced against all student groups, including and the record shows that CLS very quickly went and talked to their college Democrats and say you now have to let in Republicans, which is ridiculous, and also went to their Latino student group and said you now have to get rid of that plank that says that you're only available for Latinos, which was actually already unconstitutional. They already could have done that, but anyway. So all-comers policies, the only thing that was really holding back, though, the harm of all-comers policies was the sort of administrative nightmare of actually trying to police all of this. And the problem is that the state of California, in a case called Alpha Delta V Reed, got rid of that one last impediment by saying, oh, it's fine if this is just applied to religious groups, and it's allowing public colleges across the state of California to, empowering them at least to be able to kick off evangelical groups, even if they don't have an all-comers policy that applies to every single group on campus.
It was interesting. I mean, this meant a personal experience. It was my civil procedure professor was appointed general counsel at the University of North Carolina, Chapel Hill, and one of the first things she does is send these notices just to religious groups about non-discrimination policy, and in the attempt to de-recognize them. This was in 2003, and the university was basically chastened by the court, although now I assume they're proceeding at the University of North Carolina. It seems to be clear, what it seems to me is they want to push committed religious groups, Orthodox religious groups off campus and eliminate from the process of conversation and their attempt to talk with other students about their beliefs. They really don't want that. I want to ask you a final question with the higher education bubble. Because where does the future of this debate go? You guys have been at it for a while. It seems there's a mismatch, tenure, constant government funding. These guys don't go anywhere. They stay, I assume, until retirement. Can they replace themselves with ideological people? Maybe. But one interesting wrinkle is this bubble, this fact that the loans, the student debt, et cetera, and then now online education seems to be challenging kind of this dominant model we've had, since World War II. It seems of students leaving en masse and going and staying on campus and being subject to this. Does this offer any sort of change?
I think that given the skyrocketing cost of higher education, there's been skyrocketing costs. There's been evidence of a big decrease in rigor at universities. So you're paying far, far more for far, far less. And there's just so long you can keep this expansion going without getting some serious pushback. And it certainly is beginning, with some online competition. But I do think that, in a sense, higher education bubble does actually provide an opportunity. It's putting a much-needed skeptical spotlight on the way we run our universities. And I'm hopeful that in the inevitable push for greater reform, that there'll be an opportunity for some creative destruction. And I believe and I hope that a university that wants to compete and wants to sort of challenge the existing model will quickly understand the importance of emphasizing free speech and due process for a meaningful, meaty education.
Greg, thank you so much for your time. The book is Unlearning Liberty, Campus Censorship and the End of American Debate. Greg Lukianoff, appreciate you being with us, and best of success with making these arguments and the book being noticed and receiving the attention it deserves.
Great. Thank you.
Thank you. This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.